Very, very good evening to everybody who's already with us, and to all of us present and to all of us watching on the Center for the Study of Society and Secularism Facebook page live. We would like to welcome you collectively to this lecture in memory of Justice Hosbet Suresh on a very special occasion. And the occasion is the Dr. Asghar Engineer Lifetime Achievement Award 2020, which is being conferred posthumously on none less than Justice Hosbet Suresh. It gives us all great pleasure on behalf of the Bora Youth Association Sansthan, the Central Board of the Dawoodi Bora Community, the Institute of Islamic Studies, the Center for the Study of Society and Secularism, People's Watch Tamil Nadu, Majlis Law Center, and the Citizen for Justice and Peace, Mumbai, to co-host this event this evening. It gives us even greater pleasure to have with us none less than Justice A.P. Shah, the former chairperson of the Law Commission of India and former Chief Justice of the Delhi High Court, to deliver the memorial lecture today, The Supreme Court in Decline, Forgotten Freedoms and Eroded Rights, and to have Senior Counsel Dushyant Dave, President of the Supreme Court Bar Association, in the chair. We have also with us Justice Hosbet Suresh's family, who has accepted this award very, very graciously. And I'd like to conclude these opening remarks by simply saying that the speakers today, the delivery of the memorial lecture, and the memory in whom the lecture is being given and the award is being awarded, both Asghar Engineer and Justice Hosbet Suresh are persons among whom upheld the civilizational ethos of India, the constitutional ethos of India, and always swam against the tide, speaking up for the real values of equality, non-discrimination, and dignity. And no wonder then today, Justice A.P. Shah, in the presence of Justice Dushyant Dave, will be delivering this lecture today. Welcome all of you. We really expect a large gathering. There are many, many young persons, lawyers, activists, etc., who have joined us today. And it gives us all great pleasure to begin today. Welcome all.
We now invite Commander Mansoor Ali Bora to say a few words about Dr. Asghar Ali Engineer. Suraj, unmute.
Could unmute himself. I have already
Commander Sahab,
made the
unmute
host.
yourself.
Yeah, there you go.
Hello.
Yes, you are audible.
Okay. I am speaking from Udaipur, Rajasthan on behalf of Bora Youth Sansthan and Central Board of the Dawoodi Bora Community. Udaipur was Janbhumi and Karmbhumi of Dr. Asghar Ali Engineer, as he was born in a small town of Udaipur district, and he spent all his life in supporting and leading the reform movement, Bora reform movement from Udaipur. I will endeavor to compress his brief introduction in the available time to me. As we all know, Asghar Ali Engineer is introduced mainly under three main titles. First, as Islamic scholar, then a reformist leader of the Dawoodi Bora community, and then as a secular social activist. In all these three fields, he has excelled, and his activities and his contributions have been recognized worldwide. To begin with, since he was born in a religious priest house, he was having the advantage of receiving religious education right in his childhood, and subsequently his keen interest in Quranic studies and Hadith literature made him a scholar of Islamic studies. To advance it further, he established in 1984 an Institute of Islamic Studies to facilitate public participation and research in advanced studies of Islamic literature. However, his understanding and interpretation of Islamic scripture differed radically from the conventional understanding and interpretations. This, coupled with his image as a leftist intellectual, at times brought him in contact with traditional Muslim ulama. However, over a period of time, his forceful representation of Islam through his writings and lectures in national and international fora made him an Islamic scholar at a time when forces inimical to Islam made it synonymous terror. Asghar forcefully projected Islam as an egalitarian religion, commanding distributive justice, acceptance of all human beings as equals, respect for dignity of all humans as children of Adam, and as such advocacy of genital justice, acceptance of religious, racial, and cultural diversities, and elevating diversities as creation of Allah. In sum, he brought to fore Quranic fundamental values of mercy, benevolence, compassion, and forgiveness, thereby challenging the prevailing negative image of Islam. All this he did quoting verses from Quran and authentic Hadith literature. At the same time, he compiled many books on various aspects of Islamic teachings. His efforts thus brought him in list of progressive Islamic thinkers of modern and postmodern time. Islamic world had to ultimately recognize him as an image builder of Islam, and consequently a seminary in Saharanpur in Uttar Pradesh awarded him title of Fakhr-e-Millat, which means pride of the Muslim community. And government of Saudi Arabia invited him for Hajj pilgrimage as a state guest. The his contribution as a Bohra reform movement in brief is that Bohras are not Bohras at the time of birth, but they become Bohra only after giving an oath of allegiance to the religious head called Sayyidna. This oath of allegiance is a statement which, if read in sequence, then it shows that a Bohra becomes, after at the age of puberty, a slave of Sayyidna Sahib. The reformists at Udaipur tried to demand separation of the secular from the religious as far as this particular oath of allegiance is concerned. This reform movement has been going on from time to time for about more than a century, but they all flopped because they didn't have mass support. At Udaipur, things were different, and it was in the form of a mass support, and later on it became more forceful and more effective when Asghar Sahab not only joined it, but led it from the front and made it a global phenomenon. And today, this movement has already celebrated its 50th birthday. In February, we have celebrated our Golden Jubilee. Reform movements in Bohra community will continue, and Central Board is an umbrella organization for all the reformist Bohras throughout the world, and it was basically founded by Asghar Sahib himself. Now it comes to secular activists, secularism, communal harmony, and peaceful coexistence based on interfaith and intrafaith dialogue, protection and advancement of fundamental and human rights of citizens have been the hallmark of Dr. Engineer's social activism. For advancement of this, he established CSSS in 1994 and made it a center for activism. He has penned a number of books and published innumerable pamphlets on matters concerning these subjects. Every fortnight he used to write one essay under a secular perspective. At a great personal risk, he had covered each and every communal right reports on them. He also compiled many fact-finding reports on communal violence and natural disasters. His efforts have been recognized, and he has earned many laurels in his life, of which Right Livelihood Award in 2004 and two successive Communal Harmony Awards, one by Government of India and other by Maulana Mewar Hakim Khan Soor Award for Communal Harmony stand apart. All his achievements and his work and experiences have been penned in his biography, A Living Faith, My Quest for Peace, Harmony and Social Change. This book was released in 2011 by the then Vice President of India, Hamid Ansari. It is our honor of Udaipuris and the reformists that we had a person like Asghar Engineer, and we feel honored to be a part of this particular function. and for being a sponsor of the award in his name, which he very much deserved. Thank you very much.
Thank you, Mansoor Bhai. Dr. Asghar Ali Engineer Lifetime Achievement Award was instituted last year by Central Board of Dawoodi Bohra Community, Center for Study of Society and Secularism, Institute of Islamic Studies, and Bohra Youth Sansthan. These organizations have instituted Asghar Ali Engineer Memorial Lifetime Achievement Award to be presented to a person or an organization who has contributed in a sustained and substantial manner to promote the legacy or the area of work of Dr. Asghar Ali Engineer and encouraging others to take up similar work for a just and peaceful society in the areas mentioned in the eligibility criteria. The eligibility criteria are 5. To promote liberal and progressive reforms within any religious community. One who has contributed to liberation theology in Islam or scholarship of liberal Islam. 3. Rights of women in Islam. 4. Communal harmony and peaceful coexistence. And we believe this award is being given this year to Justice Suresh because he has contributed in this area. The area of work of candidate must be related to India. The work of contribution of the candidate in one area from the above should not be in conflict or contradiction with other areas mentioned above. Anyone except Dr. Asghar Ali Engineer Memorial Award jury and screening committee members can propose any individuals or organizations except close relatives of their own or their own organization to be considered for the award. The prize carries a cash prize of 25,000 rupees and a memento. Last year, the award was given to K.P. Ramanunni and it has been instituted from last year. K.P. Ramanunni also works for Communal Harmony. He's a Malayali writer, has contributed immensely, study of Sufism, taken yatras from Hindu temples to Sufi shrines and reduced tension. The jury then were Harsh Mandar, Dr. Sayyeda Hamid, and Professor Rovina Robinson. This year, we did not follow the jury system. All the 4 organizations unanimously decided that this award should be given to Justice Suresh posthumously. Thank you for, and now I invite Suraj to start a video on Justice Suresh.
Yeah, thank you, sir.
We'll be seeing a video on Justice Suresh, his life and his contribution.
Justice Hosbet Suresh. Will he be remembered as giant gentleman for the fact that any citizen, highbrow or marginalized, felt safe with him as a judge? Just like his mentor, Justice Krishna, Justice Hosbet Suresh, believed that the function of a judge on the bench was to deliver justice, much more to ensure that the fundamental rights guaranteed under the Constitution and the directive principles of state policy aim to make sure there is a redistribution of resources and Indian society becomes more socially and economically just.
Justice Suresh and my father, Dr. Asghar Ali Engineer, were great friends. Justice Suresh retired in 1991 from Judgeship of High Court. There were riots in Mumbai in December 1992 and 1993 3 January. My father established Center for Study of Society and Secularism as an institution to fight communal politics. We trained, we organized a number of workshops, seminars, lectures to promote communal harmony. Justice Suresh and my father came together. Whenever there was any program of Center for Study of Society and Secularism, Justice Suresh was there in that program, whether it be secularism or training workshop. Together they worked for communal harmony and opposed communal politics and for minority rights.
I can honestly say that we were very lucky to have a father like him. He had a really modern outlook, far ahead of his generation, and gave us every opportunity to stand by our own reasoning and take our own decisions, make our own choices right from an early age. There were no gender biases either, and we were all treated as equal individuals.
Justice Suresh, though hailing from Mumbai, spent many of his post-retirement days in the state of Tamil Nadu, conducting what are popularly now known as People's Tribunals or People's Inquests. These are tribunals with a new type of people's jurisprudence, of raising issues that affect a large number of ordinary people and which the courts of law as well as the national and state human rights institutions have not paid adequate attention to. Justice Suresh ensured that the jury drawn from academia, justice system and other senior social workers and experts got trained of how to conduct these public hearings in a participatory process, where the audience was able to communicate with the jury and get strengthened and empowered.
His commitment to gender justice was immense, and it is for this reason he was very much concerned about the work of Majlis, the litigation work that young lawyers do, and he was always encouraging our young team of lawyers to push the boundaries of law, to defend the rights of women.
A credo by which Indian society and state held itself together. Social justice was a must. Rare is that judge who recognizes that there are cracks within our criminal justice system. And there was born the people's human rights jurisprudence pioneered by Justice Krishna and Justice Suresh.
It is for this reason all of us are very deeply grateful to him and will always remember him as one of our great trustees. And we will find it very difficult to fill the void he has left behind.
We miss you, Papa. We love you.
दुनिया को बदलने की लड़ाई में अपने प्राणों की आहुति देने वाले शहीदों, देश की मिट्टी के कण कण में तुम्हारे बलिदान की हुंकार है, जर्रे जर्रे में तुम्हारा ख्वाब है। शोषण विहीन समाज की रचना में तुम्हारे दिखाए रास्ते पर जिंदगी का कारवां थमेगा नहीं, चलता रहेगा, बढ़ता रहेगा।
लड़ती रहेगी, गाती रहेगी, लड़ती रहेगी, गाती रहेगी। नदियाँ बहती रहेंगी, नदियाँ बहती रहेंगी।
Thank you, Suraj, for that video. Now it is my pleasant duty to read out the citation that was handed over to Rajini, Shalini, and Malini, who are present here in this video meeting and are seeing us. So this was the citation that was handed over to them, and this is why the award has been given. Justice Suresh will be remembered as a beacon of hope who championed the cause of justice for the most marginalized in India. He was appointed as a permanent judge of the Bombay High Court on June 12, 1987 and retired on July 19, 1991. Among his memorable judgments is the landmark judgment in Subhash Desai versus Sharad J. Rao case, setting aside election of a member of Maharashtra Legislative Assembly for use of religion in canvassing for votes. Committed to the values of secularism and social justice as enshrined in the Constitution, Justice Suresh fearlessly lent his voice of conscience to many causes after his retirement. As a member of Indian People's Tribunal, he was instrumental in investigating and documenting human rights violations during the 1991 linguistic riots in Bangalore and the communal riots in 1992-93 in Mumbai after the demolition of Babri Masjid. In 1994, Justice Suresh wrote the report titled Forced Evictions and an Indian People's Tribunal Inquiry into the Brutal Demolitions of Pavement and Slum Dwellers' Homes on eviction by the civic authorities in Mumbai. In 1995, his report on harmful effects of prawn farming on the eastern coast led the Supreme Court to order a ban on prawn cultivation. Crimes Against Humanity, Gujarat 2002, a report of the Concerned Citizens Tribunal headed by Justice V.R. Krishna Iyer also had Justice Hosbet Suresh and Justice P.B. Sawant as members. The other senior advocates and activists also participated in path-breaking inquiry that was example of meticulous documentation, path-breaking evidence collection, recording as many as 18,000 testimonies. This report has relevance even today. Justice Suresh also headed the tribunal to investigate the human rights violation in Kashmir Valley. His unwavering commitment to justice for the most oppressed and powerless Dalits and Adivasis, towards which he worked tirelessly till the very end. His simplicity and humility has been an inspiration to his contemporaries and will continue to motivate generations to come. It is a great honor for Center for Study of Society and Secularism, Central Board of the Awadhi Bohra Community, Institute of Islamic Studies, and Bohra Youth Association to confer Dr. Asghar Ali Engineer Memorial Award for Lifetime Achievement 2020 posthumously on Justice Hosbet Suresh on 18th day of September 2020. Earlier in the day, we had conferred this award, and now I request Suraj to show the video of conferment of this award, which will take about 2.5 minutes.
Yeah, thank you.
Good evening and welcome. It's my pleasant duty to welcome Rajni Sandur, Shalini Prasad and Malini Kanal, all daughters of Justice Hosbet Suresh, to the office of Center for Study of Society and Secularism. Along with me, Vice President of our organization, Sanjay Matre, is also present. Both of us welcome the daughters of Justice Suresh, and they have come here. We have invited them here to receive award, Dr. Asghar Ali Engineer Lifetime Achievement Award on behalf of their father, Justice Suresh, posthumously. It's my pleasant duty to hand over this award. Justice Suresh, in his lifetime, fought while on bench and after retirement for human rights of the most marginalized and weaker sections of the society. He developed the whole jurisprudence of people's human rights. And it is my pleasant duty to now hand over this award to the daughters of Justice Suresh on behalf, and they are receiving it on behalf of their father, Justice Suresh. On this occasion, we also hand them a cash award of 25,000 rupees as a part of this award. We are truly honored that they have received this award. In fact, by receiving this award on behalf of their father, they are honoring us. Thank you for receiving this award.
Thank you.
Do you want to say a few words?
All of us. We also stand with her. There, you look at the camera. Yeah.
We are truly honored to receive this award on behalf of our father. As a father, he taught us all to be fair, honest people. He supported us, yet encouraged us to be independent in both thought and action. As a judge, he was always concerned about the less fortunate and the disadvantaged. He felt for their plight deeply and had the conviction that it was his duty to deliver them justice. As a retired judge, he knew he could take this fight further. Through the various groups he was associated with, the umpteen inquiries he was a part of, the numerous articles he wrote, the books he authored, he strove to make a difference. Today, this award is proof that he did. He left a legacy behind, one that we hope all those he touched with his selfless work will take forward. Thank you.
We now invite Advocate Mihir Desai to moderate the further session, to introduce Justice A.P. Shah and Senior Advocate of Supreme Court, Advocate Dushyant Dave, and conduct the further session. Request all those who want to ask questions at the end of the lecture to please ask your questions in the chat box by typing it in the chat box. Mihir.
Thank you, Irfan. I have been tasked with, to begin with, introducing Justice A.P. Shah and Mr. Dushyant Dave. There are judges who decide from their head. There are judges who decide from their heart. And of course, there are judges who decide for other reasons. Justice A.P. Shah, of course, is the one who always used to decide from both head and heart. Because there can be sometimes a passionate judgment which doesn't necessarily meet the requirements of the law. But Justice Shah used to always ensure that it meets both the requirements. My memories of Justice Shah go back to when I was a young lawyer, and he was one of the top leading lawyers, leading counsels of Bombay High Court, briefed in all kinds of matters by all and sundry. And then, of course, in 1992, he became a judge of the Bombay High Court, and thereafter he became a judge of the Chief Justice of Madras High Court, and finally of the Supreme of the Delhi High Court. We used to say when he went to Madras as well as Delhi that Bombay's loss is Madras's gain, and Bombay's loss is Delhi's gain. And of course, I must say that Delhi's gain was Supreme Court's loss. That's one thing I must very frankly say. Justice Shah, of course, is known nationally and internationally for presiding over a bench which decided about the decriminalization of 377, but it would be unfair to just look at that one judgment of Justice A.P. Shah, which undoubtedly was a historic judgment, because he has, I mean, in my own experience, he has given so many excellent judgments. whether it's right to food, I remember he handled a right to food petition in Bombay High Court, whether it pertains to land acquisition, whether it pertains to various other issues, where numerous judgments were delivered, orders were given by Justice A.P. Shah in Bombay, in Madras, and in Delhi. And he was an extremely popular judge, because good judges are not necessarily always popular, but he was an extremely popular and well-loved judge by the bar, which is itself a very, very significant thing. After his retirement in 2010, he of course was the chairperson of the 20th Law Commission of India. And even after that, even after he gave up that post, he has been extremely active in his post-retirement life in supporting all kinds of movements, all kinds of issues pertaining to the marginalized, pertaining to the people who are in the margins of society, rushing from one meeting to another, writing extensively, speaking boldly. And so this is Justice A.P. Shah, who is going to speak today. Mr. Dushyant Dave, senior advocate of Supreme Court, with whom also I have had experience of working on some cases, is presently, of course, the president of the Supreme Court Bar Association. Apart from being a very senior and highly briefed lawyer in Supreme Court and in all kinds of cases, he was also the member of the National Legal Services Authority, the highest statutory body responsible for legal aid in India. He's, all those who know, I mean, I don't need to introduce either of the speakers really speaking, but all those who know Dushyant Dave know him for his extreme articulation and complete boldness, both in and outside court, both through his writings as well as when he speaks. And he speaks truth to power, which is very, very important in these days. And therefore, I think he's the right choice today for us to have as a chairperson of this meeting. I will stop here and request Justice A.P. Shah to give his lecture. Thank you very much.
Thank you, Mihir. Good evening to all of you present here today. I would like to extend my thanks to Mr. Irfan Engineer for having organized this event and invited me to be a part of it. And I'm delighted to be sharing the same space with Mr. Dushyant Dave. When Mr. Engineer informed me that Justice Suresh was going to be posthumously awarded the Dr. Asghar Engineer Lifetime Achievement Award, it struck me that there could be no better person for this recognition. I was fortunate to have met Dr. Engineer once, and of course known and appeared before Justice Suresh several times. Both men were similar in many ways. Both were activists in their own right. Dr. Engineer was a reformist and fought for change in the Dawoodi Bohra community, and his valuable contributions to studies in peace, non-violence, and communal harmony are well regarded. Equally, Justice Suresh was known, especially in his 3 decades of public life after retirement, for his path-breaking contributions to human rights space. Wherever there were instances or occasions of human rights violations, Justice Suresh's wisdom, presence, and support always made an appearance. The commitment of Dr. Engineer and Justice Suresh to their causes and what they identified as their life missions was unshakable. Even in the face of physical and verbal abuse, which both men had to face to varying degrees, they continued to stand tall, perhaps aware that their display of such courage under fire was necessary to set an example for ordinary people like us to keep fighting for just causes. Justice Suresh said, his voice was his conscience, which was also the title of a book he wrote. This applies to Dr. Engineer in equal terms. I would say that both their voices were the conscience of the nation, and we should be ever grateful to them for showing us all the path. Ladies and gentlemen, it is in this spirit that I speak here today of what I believe is one of the most troubling developments of our time, the decline of the Indian Supreme Court. As a former judge, at the very least, I believe it is my duty to ring some warning bells. The political thinker Edmund Burke said that judges are trained so that they can detect misgovernment and especially sniff the approach of tyranny in every political breeze. This is the kind of court we need. But unfortunately, this is not the kind of court we write now. The Supreme Court has had a glorious past that it should be proud of. The statesmanship that the 13 judges constitutional bench exhibited in the decision in Keshavananda Bharati, where the basic structure doctrine was laid down and judicial custody of the constitution reclaimed, is but one shining example of what the court is capable of. Indeed, Granville Austin said that the court had established itself as the logical primary custodian of the Constitution and its interpreter and guardian. The Supreme Court started off as a passive court. Slowly but surely, as the institution understood its role in the governance of the nation, it expanded its authority, thus laying the foundation for an activist role in future. Keshavananda Bharati was the start of all this. Over the years, there were many judgments that cemented the Supreme Court's identity further. Notable amongst these were Maneka Gandhi, Francis Coralie Mullin, and International Airports Authority, where variously due process was introduced and there was an expansion of the rights enshrined in Article 21 of the Constitution. The invention of the public interest litigation marked the beginning of what has been termed the socialist judicial era, where the court activist role came into prominence. In the late 90s, it expanded its scope into relatively less explored territories such as environmental protection, using its powers to tackle important questions in that area. In doing so, it also entered the domain of executive and was roundly criticized for this. The criticism is not entirely unwarranted, and indeed, even though it has its advantages, and there is a tendency to praise the instrument, the PIL has been abused on some occasions, but this is not the place to talk about it. It is not as though the Supreme Court did not have its ups and downs. Most notoriously, in the ADM Jabalpur case, there was a moment of realization that the court had gone astray, and the years that followed were doggedly spent in restoring some respectability to the institution. The 80s and 90s reversed its reputation, and for a brief period it seemed as though the Supreme Court had returned to being the sentinel on the qui vive, which the first generation of judges had hoped it would remain. Now, however, we seem to have regressed once again and desperately need a wake-up call in order to avoid another emergency-like disaster. You may all ask, why is all relevant? Why this is relevant? On paper, we have a liberal, democratic, secular republic with all its wheels in place. We have fundamental rights tightly ensconced behind seemingly impenetrable firewalls. With a parliamentary system of government, separation of powers, and a federated division of responsibilities between the center and states, we have a system that is the envy of many. On paper, the all-powerful executive is held accountable to the people through the legislature and to the constitution and the rule of law through the judiciary and through other institutions like the Auditor General, the Election Commission, a human rights watchdog, and anti-corruption bodies, besides entities like the press, academia, and civil society. Unfortunately, remember what I said, this is all only on paper. In India today, every institution, mechanism, or tool that is designed to hold the executive accountable is being systematically destroyed. This destruction began in 2014 when the BJP government came into power. There is a temptation to compare this with the blatant destruction that the Indira Gandhi government indulged in the past, but comparisons are odious. What we are witnessing today is a force in action, strategically intending to render the Indian democratic state practically comatose with all the power entrusted with the executive. Besides the various limitations of parliament that have been revealed in the recent past, it has not even met during the COVID-19 induced lockdown. And even when it finally decided to meet, question hour has been scrapped. Even if parliament has been debilitated, other entities should have stepped up to the plate and kept the executive in check. We have heard nothing of the Lokpal since forever. The National Human Rights Commission is dormant. Investigative agencies are misused at the slightest opportunity. The Election Commission of India appears to have been suspiciously compromised. The Information Commission is almost non-functional. The list is long and troubling. Even academia, the press, and civil society have been systematically destroyed or silenced. Universities are under attack daily, whether it is students being accused of rioting or teachers being accused of criminal conspiracy. The idea of an unbiased mainstream fourth estate in India died its death a long time ago. And civil society is being slowly but surely strangled through various ways. But the most worrying of all is the state of judiciary. There are many important issues that need to be deliberated upon today. With Parliament already so weakened, the Supreme Court would have been the next best place to discuss the Kashmir bifurcation, the constitutional validity of the Citizenship Amendment Act, suppression and criminalization of protests against the law, misuse of draconian laws like sedition and the Unlawful Activities Prevention Act, electoral bonds, etc. Sadly, most of these are ignored or brushed aside or mysteriously kept pending for an indefinite period of time. We might not be in a state of war, but we are in a state of emergency, unprecedented for generation. Central to all this, and certainly of most concern to me, is the role of the Supreme Court. In my view, the start of the court's decline coincided with the coming to power of the BJP-led NDA government in 2014. No one will deny that the NDA government swept in a new political wave, an ideology that was less centrist than we were accustomed to in the previous years, and arguably far more right-wing than what it had exhibited in its previous avatar. The Supreme Court's dissent was not fortuitous or coincidental, but was part of a larger, deliberately crafted strategy on the part of the executive to seize control of the arms of the state in ways that would benefit to its own political agenda. There was an immediate confrontation upon the NDA taking over in the form of the constitutional validity of the National Judicial Appointments Commission in 2015. The court, in a bold display of independence of spirit, struck down the legislation. Indeed, the court's engagement with the newly appointed government of 2014 onwards began well. The court mostly stood its ground against the executive, and shone particularly brightly in matters of judicial appointments. But this is sadly all gone today. We know that the appointments of new judges and transfers of existing judges across high courts many a times are decided or even arguably orchestrated by the law ministry. Recent instances of the transfers of Justices Akhil Qureshi, Muralidhar, Jayant Patel were all eminently questionable, but the court did not utter a word and quietly allowed the judges to be relocated. All of the bombast about the fiercely protecting independence expressed in the NJAC case seems to have been thrown to the wind. There was a brief watershed moment with the January 2018 press conference, where 4 Supreme Court judges, in an unprecedented move, went public with their grievances over matters of judicial administration and management. There were also some sparks of self-reflection shown occasionally, as in the right to privacy discussed in Puttaswamy, or the Shreya Singhal's case, where Section 66A of the Information Technology Act was struck down. The first time a law was struck down for violating Article 19(1)A of the Constitution, or the decriminalization of homosexuality, or recognizing transgender rights, or the many cases pertaining to gender justice, such as those on adultery, triple talaq, and promotion in the armed forces. Such as those, note however, that with the exception of Section 66A, the executive is really not concerned about these issues. But wherever the executive is an actively interested party and wants to undermine the rights of the people, usually in order to further its own realpolitik agenda, you will find that the court is being pushed to the wall. The court's proclivity to buckle in submission in matters where the executive takes a stand has not gone unnoticed. A news report by the Indian Express showed that of the recent 10 most important judgments of the Supreme Court on free speech, only 4 were decided in favor of the persons claiming the right to free speech. Critically, in all 4 of these cases, the government either supported the petitioner or expressed no objection. In contrast, wherever the government opposed, the cases failed. This is how the court seems to be turning in all matters. The court generally is becoming more prickly when it comes to issues of free speech, as evidenced in the most recent Prashant Bhushan case. In a display of self-proclaimed magnanimity, the court let off Mr. Bhushan with a fine of 1 rupee for the contempt case against him over 2 quits, but not without chastising his conduct. In the entire proceedings, one thing was clear: the court came across as an intolerant institution. The truth is that the era of the Supreme Court's glorious jurisprudence has all vanished. We seem to have only memories of its illustrious past to reminisce upon today. We were recently told in Puttaswamy case that the ghost of ADM Jabalpur had been buried deep, but I fear that these ghosts may have returned to haunt us once again. The most stark representation of the court's decline can be seen in the failure to perform as a counter-majoritarian court. I emphasize counter-majoritarianism because it is important to recognize the role of the court in protecting the interest of minorities. A democracy derives its legitimacy from representing the will of the majority. But this legitimacy comes at a cost, which is invariably borne by minority groups, and especially those that are unpopular or victims of deep prejudice and who cannot influence the legislature in any way. This power to protect minorities from the tyranny of the majority is the basis of judicial review powers that allow courts to strike down laws for violating the Constitution. Now, though it seems that the court is turning away from the decades of its own history and is instead aligning with the majoritarian view unhesitantly and without question. Two recent cases which demonstrate this clearly are Sabrimala and Ayodhya. The original 2018 Supreme Court judgment in Sabrimala was extremely progressive one. It permitted the entry of women into the Sabrimala temple in Kerala. But when the Kerala state government tried to implement the court's judgment, the BJP-led centre sided with Ayyappa devotees. The court's word should have been final, but the central government seemed to believe that that was not the case. Soon after, review petitions were filed, but these were kept pending for certain referred questions to be decided by a larger bench. There was no stay on the main judgment, but the court said that the referral meant that the judgment was not final and therefore refused to issue directions on a petition for seeking safe entry into Sabrimala. This has opened up a Pandora's box of nightmares that we might live to regret. It means the central government can, with impunity, ignore the Supreme Court and that judgments can be conveniently reopened, though through referrals in the guise of reviews. What implications does this have for the rule of law? The issue of rule of law and finality also came up in the Ayodhya judgment. It is unanimous, but unusually anonymous decision on an essentially a political issue. The court said that the Allahabad High Court's decision to divide the property into three parts was not feasible in order to maintain peace and tranquility. However, did the Supreme Court judgment result in complete justice? Despite acknowledging the illegalities committed by the Hindus in 1949 and 1992, the court effectively rewarded the wrongdoer. Surely this is against the doctrine of equity, where one must approach the court with clean hands. Just as the central government exhibited impunity in the Sabrimala judgment, in the Ayodhya case too, the Hindu Mahasabha pressed for the withdrawal of criminal cases against the car sevaks involved in the 1992 demolition and violence. It also demanded that the car sevaks be given government pensions and their names listed in the temple on the site of the masjid as though they were freedom fighters. The Supreme Court has said that the criminal cases must continue. But in the larger scheme of things, I'm doubtful if any meaningful result will emerge. The failure to remain committed to the Constitution, as demonstrated by the court's jurisprudence on Article 21, is becoming increasingly visible. In the face of the colossal public health crisis caused by COVID-19, the lives of migrant laborers have turned upside down. They have no work, no source of income, no access to basic necessities, and no means to reach home. Instead of taking on petitions questioning the situation, for the longest time, the court refused to admit or adjourn these petitions. In rejecting or adjourning these petitions, the court made several questionable remarks. It said that the governments already provided laborers with 2 square meals a day. So what more could they possibly need? And that incidents like the horrific accident where migrant laborers sleeping on the railway tracks were killed could not be avoided, because how can such things be stopped? Many of the so-called excuses of the court have been tackled by previous judgments, notably the question of policy and non-judicial interference. For instance, the right to food, various environmental protection policies. In these cases, the court formulated policies and asked states to implement them. In the migrant workers case, though it made the unfortunate presumption that the government is the best judge of the situation, the suo motu recognition of the issue by the court also came too late. Instead, the high courts came across as islands of rationality, courage, and compassion in these times, asking questions about migrant rights. Contrast this with the Supreme Court's reaction to the bizarre claim of the Solicitor General, who argued that the exodus of workers was due to fake news. The court accepted this, and media houses were advised to report more responsibly. Our Supreme Court today, sadly, has time for $1 billion Indian cricket administration or the grievances of a high-profile journalist, but studiously ignored the real plight of millions of migrants who do not have either the money or the profile to compete for precious judicial time with other litigants. Another kind of repression that is happening, perhaps unprecedented in modern India, is the stifling of the right to protest and to free speech. The executive is spearheading this, and the judiciary is either tacitly agreeing with the executive overtly or maintaining silence around the issue. If we want to boast about being citizens of a democratic nation, this ought to be the first thing that worries us. Take the protest against the clearly unconstitutional Citizenship Amendment Act, the CAA. The constitutionality of the law was challenged in the Supreme Court, but the court itself avoided taking up the matter for flimsy reasons. Meanwhile, the government has desperately tried to silence protesters. Indeed, the government is using every imaginable means to silence any or all dissenting opinion and to clamp down on any alternative views that might exist. More problematically, the judiciary is watching all this happen by the sidelines, like a mute spectator without uttering a word. Different strategies are employed in different states. In Uttar Pradesh, its chief minister said that he would take revenge against protesters and that chanting Azadi or freedom would amount to sedition. Police have been given license to run riot against peaceful protesters by arresting them, destroying vehicles, and even entering homes. Targets tends to be Muslim youth. A combination of charges under the National Security Act and Gunda Act were used in UP. But the burning issue in this context, ladies and gentlemen, has surely been in Delhi riots. The government has been targeting those who express an honest view and engage in honest protest, and even on occasion stage a play. Unarmed students have been attacked by the police. Anyone critical of the establishment, regardless of their intentions, such as Professor Apurvanand and Yogendra Yadav, are implicated at the slightest opportunity or tried to be implicated at the slightest opportunity. The strategy in Delhi has been to charge individuals with criminal offenses of rioting, unlawful assembly, criminal conspiracy, and that awful colonial legacy that is sedition, to name but a few, in conjunction with the newly interpreted Unlawful Activities Prevention Act, UAPA, contests this treatment of civilians with that of leading politicians of the ruling BJP who have publicly delivered insightful speeches. Shockingly, no punitive action was taken against them. Instead, the one judge who showed some inclination to take action was conveniently transferred. The arrest having to a template. If a person expresses a legitimate view against the CAA, he is promptly labeled an anti-national, and the law enforcement machinery kicks in. It does not matter that the CAA is blatantly unconstitutional law. The police says that the protest sought to execute a secessionist movement in the country by propagating an armed rebellion in which the anti-government feelings of the Muslims will be used at an appropriate time to destabilize the government. It's simply mind-boggling. The former police officer Julio Ribeiro has pointed out to the lack of a fair investigation in the Delhi riots, drawing similarities with the 1984 riots here. He rightly said that riots recur in India because of the impunity accorded to one section by the political establishment of the day. Police investigations in the riots have been based on mere disclosures with no concrete evidence. Surely this goes against all principles of fair investigation. By taking action against peaceful protesters, but deliberately failing to register cognizable offenses against those making the hate speeches that triggered the riots in Delhi, the Delhi police has been accused of partisan and politically motivated. With the police taking a majoritarian stance as well, effectively, the real culprits of the violence belonging to the majority community are allowed to get away. Why are the political establishment and the police so emboldened? Undoubtedly, it is because of the weak judiciary that we have in India today. Had the Supreme Court not remained a mute spectator, and had it intervened more proactively, all this would have arguably not happened. Instead, the Supreme Court conveniently declined to intervene, showing no urgency in wanting to deal with these problems. For weeks, the matters involving many of these issues, for example, the Delhi riots, kept getting adjourned. Even where matters were heard and decided, when they were appealed, there was judicial silence. When the Allahabad High Court directed that protesters' photographs put on hoarding should be pulled down in 24 hours as the action was unsupported by law, in appeal by the UP government, the two-judge Supreme Court bench agreed with the High Court on the unlawfulness of the action, but it still mysteriously made a reference to a three-judge bench, effectively permitting the state to ignore the High Court order. To make matters worse, the Supreme Court's April 2019 decision in NIA versus Zahur Watali on the interpretation of the UAPA has affected all downstream decisions involving the statute. This decision has created a new doctrine, which is that effectively an accused must remain in custody throughout the period of the trial, even if it is eventually proven that the evidence against the person was inadmissible and the accused is finally acquitted. The illogic of this veers on the absurd. Why must an accused remain in jail only to be eventually acquitted? According to the decision delivered by Justice Khanvilkar and Justice Rastogi, in considering bail applications under the UAPA, courts must presume every allegation made in the first information report to be correct. Further, bail can now be obtained only if the accused produces material to contradict the prosecution. In other words, the burden rests on the accused to disprove the allegation, which is virtually impossible in most cases. The decision has essentially excluded the question of admissibility of evidence at the stage of bail. By doing so, it has effectively excluded the Evidence Act itself, which arguably makes the decision unconstitutional. Bail hearings under the UAPA are now nothing more than mere farce. With such high barriers of proof, it is now impossible for an accused to obtain bail, and is in fact a convenient tool to put a person behind bars indefinitely. It is nothing short of a nightmare come true for arrestees. This is being abused by the government, police and prosecution liberally. Now all dissenters are routinely implicated under wild and improbable, charges of sedition or criminal conspiracy, and under the UAPA. Due to the Supreme Court judgment, the High Courts have their hands tied and must perforce refuse bail, as disproving the case is virtually impossible. As a result of this decision, for instance, a High Court judge can no longer really adjudicate and assess the evidence in a case at the stage of bail. All cases must now follow this straight-jacketed formula of refusing bail. The effect is nearly identical to the draconian preventive detention laws that existed during the emergency, where courts deprived people access to judicial remedy. If we want to prevent the disaster of that era, this decision must be urgently reversed or diluted. Otherwise, we run the risk of personal liberties being compromised very easily. This abuse of the UAPA and constant rejection of bail applications of accused as a means of silencing opposite voices can be seen most in the Bhima Koregaon cases, where mere thought has been elevated to crime. In this matter, involving the arrest of many individuals, the so-called evidence was a typed, unsigned, undated document already in the public domain, which was supposedly taken from the devices of Varavara Rao and Gautam Navlakha and attributed to them. The document titled Strategy and Tactics of the Indian Revolution was referred to in a book published 6 years ago. This document is also publicly available online. There is no Section 161 witness statement that has been relied upon in the matter of Surat Bharadwaj, which I studied very carefully. But as a consequence of UAPA being applied, the accused cannot get bail. Courts cannot go into the merits of the case due to the Supreme Court judgment. The pattern followed in these arrests are very similar. Social activists, academicians, public intellectuals who have worked in certain parts of the country are first accused of Maoist conspiracies, then with charges of misguiding Dalits, and then under the UAPA. Sudha Bharadwaj has been in jail for 2 years. Varavara Rao, a COVID-19 patient, is not allowed to get out and receive proper treatment. We hear of fresh arrests ever so often. Navlakha's case is a classic example of how the high courts are being discouraged from doing anything. Navlakha made an application for bail before a Delhi High Court judge. But when the matter was being heard, without informing the court, Navlakha was transferred to prison in Mumbai. When the judge inquired as to how and why this was done, there was no response from the government. Instead of explaining its position to the High Court, the Solicitor General took the matter to the Supreme Court, and the court simply rejected the bail application, virtually ending the proceedings before the High Court. Ladies and gentlemen, the next characteristic contributing to the Supreme Court's decline is in the failure to perform its fundamental role as adjudicator itself. In the Kashmir case, it has practically abdicated its role as a court. The court's decision in the internet shutdown case, that is Anuradha Bhasin's case, was laudable in many respects, but failed to actually decide the matter. After ruling that the suspension of communication services must adhere to the principles of necessity and proportionality, the court failed to apply these principles to actually decide the legality of the communication shutdown in Kashmir. In its later decision in May 2020, instead of itself dealing with the constitutional issues relating to Articles 14, 19, 21, proportionality, and strict scrutiny, the court merely upped and handed over the exercise of advising the court and administration on the applicability of Anuradha Bhasin to denial of 4G services in J&K to an executive-led special review committee. This is clearly a case of misguided and surely constitutionally unacceptable delegation. The executive has been asked to conduct a review of its own actions, when in fact, the judiciary should have been conducting a judicial review of executive action. As expected, the review committee rejected the representation, leaving the entire J&K population without 4G services for an unforeseeable future. It has already been over a year. Should this denial of the fundamental right and access to internet be ignored so unsettlingly? To use senior counsel Arvind Datar's phrase, this is a case of justice having been outsourced, which is arguably tantamount to justice being denied. There is also a pattern of judicial evasion being followed by the court in Kashmir cases, when petitioned as to how the internet shutdown was affecting the public health delivery system in J&K, the Supreme Court told the petitioner to approach the High Court to avail the appropriate legal remedy. The over 1.3 crore population of J&K is suffering, with health, education, business and economy all operating at a loss because of the executive's internet shutdown. The Supreme Court seems to simply not want to deal with real-world problems at all. Contrast this with how other jurisdictions have dealt with conflicts between individual liberty and national security, as described by Mr. Arvind Datar. In Liversidge versus Anderson, a Second World War case, Lord Macmillan famously observed that the fact that the nation is at war is no justification for any relaxation of the vigilance of the courts in seeing that the law is duly observed. After the September 11 attacks, the United Kingdom enacted a law to detain and deport non-UK citizens if there were suspected terror links. The law was struck down in A versus Secretary of State for the Home Department on grounds including discrimination, with the courts drawing a distinction between the subject of national security being a matter of political judgment of the executive and parliament, and the issue of whether individual rights were violated being the subject of judicial scrutiny. Elsewhere, the US Supreme Court struck down the government military commission for trying detainees in Guantanamo Bay for violating the Uniform Code of Military Justice and the Geneva Conventions in Hamdan versus Rumsfeld. Note that Hamdan was Osama bin Laden's chauffeur, but the court did not flinch. Similarly, when the Iranian bank Millet was suspected to be funding entities supporting Iran's missile program, and the UK Treasury issued a directive prohibiting dealings with the bank, the UK Supreme Court in Bank Millet versus Treasury revoked the directive for failing to balance the rights of the bank and the interests of the community. Surely, the Indian Supreme Court should have taken a leaf out of the books of its peer institutions in the US and UK and applied its own mind in such matter instead of outsourcing the justice. Ladies and gentlemen, that the judiciary is failing spectacularly to remain an independent institution is evident. That the executive is in fact responsible for this is also not an open secret. How the executive is doing this is also well known. There is no need to expend energy in packing the Supreme Court with pro-government judges. Finding over 30 judges who think alike would anyway be difficult, if not impossible. The combination of opaque system like the master of the roster means the Chief Justice has untrammeled, unrestricted rights to allocate the work to different benches. And a certain kind of Chief Justice of India and a handful of reliable judges is sufficient to destroy all that is considered precious by an independent judiciary. Of course, this is far from being a hypothetical scenario and is in fact playing out in India right now. The truly independent and competent judges in the court have been relegated to adjudicating private disputes and are considered inconsequential. Many commentators have already pointed out how the last three CJIs all use the powers anointed upon themselves via the master of the roster to entrust politically sensitive and important matters to benches involving the recently retired Justice Arun Mishra. There is a tendency to view the threat to judicial independence in India as emanating from the executive branch and occasionally the legislature. But when persons within the judiciary become pliable to the other branches, it is a different story altogether. Today's situation was foreseen many decades ago by Chief Justice Y.V. Chandrachud when in 1985 he observed there is a greater threat to the independence of the judiciary from within than without. All the sermonizing in the world that is done in contempt case of Mr. Dushyant is of no use without any real changes in the ways things work. In their book entitled How Democracies Die, Stephen Levitsky and Daniel Ziblatt write of how most democratic breakdowns have been caused not by generals, but by elected governments. They document the many instances of how elected leaders have subverted democratic institutions across the world. This subversion is carried out by the constitutional sanction of the ballot box and even with approval from the legislature and the judiciary. Throughout, there is always the assurance that the democratic wheels are still turning. Levitsky and Ziblatt call the leaders who thrive in such situations elected autocrats. Such elected autocrats weaponize institutions to use them as political ammunition. They compel the media and the private sector into silence, and they redraft rules to suit their interests over those of their political opponents. Critical voices will still rise in the backdrop, but those who dare to question the powers that be end up at the receiving end of all kinds of trouble, whether they are charged with making seditious remarks or evading taxes or some such thing. In this way, they use the very institutions of democracy to kill it. To put it bluntly, this is what is happening in India today. In the face of all this, the one institution which has the capacity to turn the tide is the judiciary. Unfortunately, it seems to have lost its way. There was a period in history during the emergency as well when the Supreme Court failed the nation, but it realized its follies and returned to its natural path in course of time. Now too, we have many judges and exemplary lawyers in practice who are sincere and committed to constitutionalism and to the rule of law. I expect they will rise to the occasion. The occasion is now. Ladies and gentlemen, more than 70 years ago, in the Constituent Assembly, Nehru had said that we needed judges of the highest integrity who would be persons who can stand up against the executive government and whoever might come in their way. I am hopeful that we'll once again be able to see judges like these thrive in India. Thank you. Thank you, Ms. Setalwad and Mr. Engineer. Thank you for inviting me this function.
Thank you, Justice Shah. That was, what would I say? It was brilliant, audacious, bold, truthful, and I hope you have kept ₹1 aside because you might need it at some from somebody who may be charged with lowering the dignity of the Supreme Court. Now I go to somebody who has just been defending somebody who was charged with lowering the dignity of the Supreme Court in possibly the most known contempt of court case in the annals of our Supreme Court. Mr. Dushyant Dave, over to you.
Good evening, everybody. After that scintillating address by Chief Justice Shah, it becomes extraordinarily difficult for me to really keep all of you, listening to me for next few minutes. But I will make an endeavor. Chief Justice Shah, you've done a great service to the nation with today's address, as you have done for a long, long time. And I do hope and trust that not just those in power, not the judges, but the citizens also will hear your views across the country and will try and emulate and try and take some corrective steps. Let me say one thing. George Floyd's death in the United States of America. What happened? Black life matters. In India, with so many killings of innocent people belonging to the minority community, belonging to the Dalit section of the society, has this country ever woken up? In a country like Belarus today, 100,000 people gather to protest against a dictator every Sunday. In India, nobody is willing to stand up and speak. Why is it? Why blame judges? Why blame Supreme Court? Why blame institutions? Why blame politicians? We, the citizens, have lost our courage to stand up and demand our rights and our dignity. And we therefore should not be blaming everybody else. Of course, they are to be blamed. But, charity begins at home. We have to somehow find that courage to stand up. Nobody says, and nobody should think of any violent protests. But the peaceful protests that George Floyd's death, evoked, not just in the United States, but across the world, is something which we should really, think of. We must put pressure. The only pressure that can work today on the constitutional institutions, including the Supreme Court, is the moral pressure. No other pressure is going to work. If anybody thinks, if Justice Shah in his last, parting remarks said that he is hopeful that judges will change, I am not at all hopeful. I do not think that, with the fall of the Supreme Court started not because of 2014. Sorry, no. The fall of the Supreme Court and judiciary started with the 1992 judgment of the Supreme Court, whereby judges grabbed upon themselves the power to appoint judges in high courts and Supreme Court. And with that became the decline. Yes, some exceptional judges have been appointed, but by and large, the appointment process has been seriously flawed. And judges have done great disservice because the collegium system works only on give and take. Every judge in a collegium has his nominees. And the three of them sit together and select their preferred nominees to recommend them for appointment as High Court and Supreme Court judges. This system has really, in fact, much prior thereto. I mean, Justice Shah will bear me out because, a man like Chief Justice P.D. Desai, I mean, perhaps Justice Shah was recommended by him. Chief Justice P.D. Desai recommended outstanding judges wherever he went. In Himachal, in Calcutta, in Bombay, and even in Gujarat while he was a senior judge. But as Chief Justice, all his recommendations were accepted. And when one recommendation was ignored and judges were appointed, a particular judge, he refused to participate in the oath-taking ceremony in Calcutta. Now, and those were the times when executive was appointing the judges in consultation with the Chief Justice. The judges have now said the executive must appoint in concurrence with the Chief Justice. And that concurrence, I must say, ladies and gentlemen, has been disastrous. Disastrous is the word. And I don't think we can change it at all. NJSC was perhaps a solution. At least we can then criticize the appointment process, the opaque, non-transparent procedure, this scratching of each other's backs that judges across the country are adopting. We can all criticize because once it is appointment by the NJSC and by the executive. Today, we are not even in a position to criticize the judges because everybody is worried about the contempt. Now, these are administrative powers, but the administrative powers are being abused by the collegiums across the country. And I would say, barring exceptions, there are exceptions. Barring exceptions, the judges are appointing really not the best from amongst those available. And that's the mandate of the second judge's judgment, that you have to appoint the best from those amongst available. And that's not happening. We all know it's not happening. We all know why it's happening. So, I mean, in a country like India, the situation is very, very difficult in last 30 years for whatever reason, let's not blame politicians alone. We, the citizens, have lost our character. And I don't know where we can rebuild it. Whether our parents are responsible, our teachers are responsible, our religious leaders are responsible, our politicians are, our role models are responsible from the films industry, our great role models. I mean, what is it that is driving this, country's citizens to complete lack of character building? Our courage has been taken away from us. So it is something where we have to begin, from the scratch to start rebuilding our character and to believe, you can't just live in the past 5,000 years of history. And you can't, as I many a times jokingly tell my friends, that we must understand as Indians, and we all are proud Indians, that we can't defeat Babur in retrospect. We have to accept the history as it was, as it unfolded, whatever it is. We must criticize Babur for what he did, but we must also appreciate Akbar for what he did. Now, this is something which we have to understand, that we have to learn to respect history in correct perspective. And all this is today happening because, because there is no voice of people. If there is a voice of people, then things can change. In India, the democracy functions only during the elections. Once the elections are over, the elected representatives don't care a damn for democracy. Then they are perpetuating their own positions, their position of their friends and their families, and consolidating power as much as they can. It is the only country where, Constitution of India does not matter at all in governance, in day-to-day governance. There is nothing called rule of law in India. Yes, it is there for the rich and the powerful, and for the people blessed like us, that there is some semblance of rule of law. But for those hundreds of millions, maybe a billion plus people who do not matter because they are poor, they come from vulnerable section of the society, rule of law is singularly absent. And this is where we need to seriously introspect as a society. We have a duty to these 130 crore people. Each one of us has a duty towards them. We have to do something so that we can really take this country forward. And we have amazing talent. Indians are second to none in the world, in every walk of life, in every field. And I can tell you that, if only we are guided by proper persons, we can really do. Now, this is not the problem of India today alone. Look at Brazil, look at Turkey, look at Belarus, look at Russia, look at even America. Every country today is being led by leaders who are dividing the society vertically. And unfortunately, liberalism is being killed slowly and steadily. Globalization is now sought to be killed. Now, can you imagine in today's world that without globalization, any country can survive? India's pharmaceutical industry, for example, almost 2/3 of its basic ingredients come from China. We have no capacity to produce them. My friends who are large pharmaceutical company owners tell me that it will take 10 years for us to establish those kind of capacities. Now, are we going to therefore survive without this kind of ingredients? What will happen to our pharma sector, which is one of the most successful business areas after technology and other areas? So, the killing of liberal thought, the killing of the large-hearted globalization is now order of the day. But it's being done by the political masters because the people are not willing to resist them. If the people were to resist, now today, for example, after the Black Lives Matters in the United States, people have really, stood up. And it has brought tremendous pressure to the extent that in some cities, the mayors are even disbanding the police organizations altogether. Now in India, we can have, encounters in UP in last 2 years where more than 500 people have been killed without, anybody raising a voice about it. The Human Rights Commission doesn't say a word. The judges, the Supreme Court and the High Court are silent about it. But the people, the silence of the people is most troubling. And it is that, inner voice, that conscience of the people which has to be stirred up. We have to, raise our stand up. We have to raise our voice and bring some pressure. Then only we can succeed. If we do not do so, individual efforts by individuals who are doing remarkable work. There are lots of individuals, Mihir Bhai here, Tista here, Justice Shah himself, late Dr. Asghar Ali, and Justice Suresh, outstanding contribution on individual basis. Their country should be proud of and is indebted to them. But does it make a difference? It doesn't make a difference, with greatest respects to them. Yes, it gives us sense of satisfaction that we have been able to give to the society what is expected of us. But what really matters is the lives of millions of Indians. And unless we can change the lives of these millions of Indians, ensure to them the constitutional goals, social justice, economic justice, fraternity. The most important goal of the Constitution is fraternity and dignity of human beings, dignity of citizens. Where is the dignity of citizens today? If relying on completely fraudulent, facts in Nizamuddin Markaz, you can criminalize sickness of a community, arrest thousands of people, and media is party to it, police is party to it, judges are singularly silent about it. I mean, is this the kind of a nation that we should be really proud of? We love our country. I'm sure every one of you loves India as much as I do. But things which are happening are unbelievable. And therefore, it is very important that nobody came to the rescue of those who were arrested. Why is it that 100,000 people did not carry out a silent march for their own brothers and sisters who were arrested because they could not leave because of 6 hours lockdown? What were they doing there? They were only praying. They were only learning tenets of religion. Nothing wrong about it, and they were doing it with permission. Can you criminalize that kind of an activity? Then why not criminalize all those who attended, 100,000 people in Ahmedabad to see President Trump? Or what is happening after that in number of series of such incidents across the country? But no, because these things are, these things give advantage to the politicians to perpetuate their power. So we have to seriously understand the nuances of the political movement in the country today. Every ideology must be respected. I am not against any ideology. If right-wingers have their ideology, I respect it. If the left-wingers have, I must respect it. But within those ideologies, we should be able to create a situation where people's dignity is maintained. The fundamental rights are ensured to them, and people are able to live with happiness and bliss in this country. During the Constituent Assembly debate, Ambedkar, Sardar Patel, and surprisingly Shyama Prasad Mukherjee, all three had consistently said one thing, and one thing which is totally forgotten by the majority community, that those Muslims who wanted to go to Pakistan have left us. But those who decided to stay back in India have left their fate in the hands of the majority. The burden is on the majority, therefore, to ensure that these minorities is protected as much as possible and to bring them into the mainstream of the life. Now, this is completely forgotten today. So and it's nothing to do with majority or minority. The rights of those who are, who don't have a voice, the Dalits, the vulnerable sections of the society, the oppressed, or the poor, are all being compromised in one form or the other on a daily basis. Therefore, as Justice Shah very rightly says, judiciary has a great role to play. The Constituent Assembly debates show that throughout the debate on independence of judiciary, when they wanted to create the courts, and particularly the Supreme Court, not just Dr. Ambedkar, not Jawaharlal Nehru, but people like Kanayalan Munshi, people like K.T. Shah, they all expressed their thoughts so vociferously and said that at all costs, independence of judiciary must be ensured when we draft the constitution. They did it. In fact, Ambedkar was, I would say, he was so futuristic in every conceivable way, including about, thinking that we might go through a dictatorship. But on judiciary's independence, I think Dr. Ambedkar perhaps has been proved to be naive, because he said again repeatedly that the functioning of the executive and judiciary is so separate that we don't have to worry about it at all. Now, little did he realize that we will have appointment of judges who will really not be able to withstand the executive's pressure. Now, that's something which really was inconceivable. And that's why he should have perhaps thought of an extremely powerful, extremely independent process of appointing judges to High Court and Supreme Court, which was not done. I think to that extent, Constitution framers perhaps never realized. They thought that goodness of the Indians will perhaps never create this problem. And NJSC was hardly an answer to that. But I personally feel that collegium system has to be dynamited. It has not served its purpose at all. Now, we have to therefore say today one thing, that we need thousands and thousands of Dr. Asghar Ali and thousands of Justice Suresh. Unless we can have those people, we really will not be able to motivate people to really understand their rights. People don't know their rights. We have to reach out to people to tell them what their rights are, how they can assert those rights, how they can really help themselves when their fundamental rights are being taken away by the government in one form or the other. It's very important. And I feel that, these kind of great people are far and few. Justice Shah, for example, is one of the exceptional judges that I have seen in judiciary in my 42 years of career. So we need judges like that. Now, I don't know, my hero was P.D. Desai all the time. And I feel that I've never seen a judge like P.D. Desai, with great respect to Justice Shah. P.D. Desai was absolutely unbelievable judge. His personal character, his personal rectitude, his judicial approach, and his bleeding heart for justice was absolutely unparalleled. So, those are the kind of judges that I have seen. And when I began my practice in 78 in Gujarat, and I don't think we will ever be able to do that, because the bar, ultimately judiciary works because of both bar and the bench. And where is the bar today? Where is the bar which is willing to stand up for people's rights? Where is the bar which is willing to speak up against failures of the judges? Maybe 1 or 2 people, 5 people. Now, is that the kind, have you ever heard a single highly successful counsel of this country criticizing judiciary? They all come on television and give us all kinds of sermons. But do they ever speak up against the judiciary's failings? They won't. Because they need to be appearing before these judges day in and day out. And they therefore feel that we can't really criticize them. So this is something which is, the role of the bar, the fallen standards of the bar is something which is to be really worried about. The bar councils across the country are not able to do anything to maintain the standards, and the lawyers, for various reasons, are not willing to really rise themselves to a situation as demanded by the present, challenges. These challenges are not new. I don't agree with Justice Shah that since 2014 alone we are facing the challenges. Even prior to 2014, I have been in Supreme Court since '86, and I can tell you that Supreme Court, time and again has done things or has conducted itself in matters which were really, I would say, not acceptable. It was not something, the Supreme Court failed again and again. The Supreme Court, I know of cases where if, man like Karunakaran is convicted by the Kerala High Court, the Supreme Court fixes the matter for mentioning in court number 9 before a convenient bench, and the stay is immediately granted. And the stay continued till the old man passed away. So it's not in isolation. These things were happening in Supreme Court even earlier. I mean, 32 petitions were filed to quash prosecution in 2G, and Supreme Court entered and quashed them. In Jayalalitha's case, after her conviction, she was protected under an ex parte order, where the judgment was stayed, allowing her to continue as chief minister, although she was convicted. So, things have happened in the past, and they are extremely troublesome. Let me put it this way, that Supreme Court has really not been a court. I mean, can you imagine that in any country of the world, a judge who is facing a sexual harassment charge, the Chief Justice, would have been allowed to continue even for a day? And he holds a hearing on his own on Saturday, abuses the poor lady, and she is dismissed. She is sent to jail. Her husband is sent to jail. And ultimately, she is reinstated with back wages when he retires. What kind of a court is this? Now, if she was guilty of having brought a false complaint, she could never have been reinstated. Her reinstatement clearly demonstrates that she was right and Chief Justice Gogoi was wrong. But this country, no voices are raised. Even women remain silent. Why didn't 100,000 women march out against that kind of a treatment to a woman? So it's something which we really, individual efforts are good enough for individuals, and it perhaps is good enough for their conscience, because then we can at least sleep peacefully at night. But it won't help the country as it needs, and it won't help 130 crore people. I would respectfully urge that we must really, and by honoring Justice Suresh, all the institutions which are behind this award ceremony, I compliment them and I really congratulate them for selecting a man like Justice Suresh, because that gives a very powerful message to the society at large, that even now good deeds can be rewarded. And that's something which is very, very important. Late Dr. Asghar Ali, has contributed.
What is it, Baba?
That's why he lives in the hearts of, millions of people. And that's what really matters, that people like them have really left an indelible mark in the society. And we therefore today, at least remembering them, reminiscing their lives, really are sending a very strong message to the next generation. Our generation has failed. Let me honestly concede to that. But the next generation of Indians must really think about future of India. They must really do something, start working to rebuild India on the constitutional goals, on the constitutional lines, and to bring the dignity of the Indians. So I think it's very, very important for us to understand and move forward. Once again, I thank the organizers for inviting me. It's been a pleasure and a privilege. I thank Mihir for his kind words. I'm really grateful to Mr. Irfan Engineer for being, very, very kind to me in having, spoken to me again and again about this event, and having really been responsible for inviting me to chair this. It's been my privilege and pleasure. And thank you, Justice Shah, once again, on behalf of all the Indians. I say that thank you very much. It's been a great, it's been really great to listen to your views, your thoughts, which are not too many coming in today's times. And I do hope that perhaps your voice would be heard, at least by some of the judges, if not all the judges, and maybe things might improve. Maybe your hopes may turn out to be right. I wish you good luck in that. Thank you very, very much. And I end by giving my respectful and full-handed homage to late Dr. Asghar Ali and Justice Suresh, and pray that they continue to guide us. Thank you very, very much.
Thank you, Dushyant Bhai. We have listened to two extremely bold as well as passionate speeches today. There is one thing I would disagree with you, Dushyant Bhai, and the disagreement is that when you mentioned that show me one successful senior counsel who goes on TV and speaks boldly. Well, we just heard one of them. So then you are completely wrong. But I think even if we take the passion and the boldness out of these two talks which we have heard today, from different angles. I mean, both of them, both Justice Shah as well as Dushyant Bhai have at one level they express a deep anguish and pain about what is happening in the country today, in the Supreme Court today. But they also expressed the boldness as well as the passion which is required for all of us in order to change the situation. And I hope if we are able to take that away from today's meeting, a lot can be achieved. And I can see that today's meeting, the participants have been quite a lot on Zoom, as well as I'm sure on Facebook. I hope, Irfan, I would request you that today's speeches, if you can publish them, apart from taping and available on tape, but if you can publish them, that would be a great service. May I now request Tista to moderate the session on question and answer, please. Tista, over to you.
Thank you, Mir. Thank you so much. I will quickly get to the questions and not express any of, though one is feeling very humbled and overwhelmed, but I'll get to the questions because we have many questions and Irfan tells me that I need to be very clear of cut-off time. So I just want to tell the persons who have asked the questions that please forgive me if some questions are omitted because we have a limitation of time. The first question, Justice Shah, is from a very eminent historian, Harbans Mukhya ji, and he's put this question to you. The question is that while the Constitution is the ultimate guardian of not only individuals but also the nation's various freedoms, yet it has also provided space for the virtual decimation of these freedoms by a regime unmindful of their sanctity. Is there a way to ensure this sanctity of the Constitution? Justice Shah.
Sir, you need to unmute.
Justice Shah, unmute yourself. Justice Shah, you have to unmute yourself.
Yes, sister, sorry.
Should I read it? Should I read it again?
No, don't repeat.
Yeah,
I
sorry.
heard the question.
Yeah.
You see, to ensure the adherence of the successive governments to the Constitution is through the ballot box as of today. Though Dushyant has mentioned about the people's struggle, bringing moral pressure as what happened in USA, in Black Lives Matter. But I personally feel that there should be, and there are various checks and balances. What happened, according to me, is in last several years, those checks and balances are slowly diminishing. That is the tragedy of the system. For example, the parliament. I mean, most of the nations held their parliaments. Only Indian parliament was not convened during the entire period of COVID. And when it was convened, I mean, it's a half-baked, without a question of her. So, see, how do you strengthen your the checks and balances and the accounting mechanism? That's the key to the implementation of the constitutional codes.
Thank you, Justice Shah. Another question is this one is to Justice. This one is to Dushyant Javedi. Dushyant, this is for you. That even in cases when the police makes an arrest without much of a visible offense, the arrested is punished and he or she is expected to approach the court where she may or may not get any relief. What kind of law and democracy is there in India if there is nothing certain under the law? What does a person do who does not have money and guts to file a case before the court? And one personal question is, what was it like to be in the Supreme Court when you were arguing in the contempt case for Mr. Prashant Bhushan? I combined two questions.
So far as the first question is concerned, yes, it is a matter of grave concern that individuals are denied justice by the judicial system. And I mean, there are many reasons for it. And one of the singular reasons is that the judges are not proactive in criminal trials as they are expected to be. In fact, Criminal Procedure Code demands that judges become proactive, and they should really be testing the evidence at every stage, right from the word go, to understand whether there is any material against a person who's been brought before the court. And that's not happening. And the reason is manifold. I mean, this used to happen good old times. Now, with the appointment of more poor and poor judges in the system, things are becoming very difficult. Good lawyers are unwilling to become judges, and as a result, we are not getting the most meritorious people to man the judicial system. And that is a real challenge that we are facing. So yes, and I must say that legal aid service, which is expected to do something good, is not able to really help these people. For example, I am so frustrated that in last almost since 86, I've been in Supreme Court. Legal aid committee has referred only one matter to me, which was to file a curative petition. I gave a long opinion saying why the judgment under review was wrong and that curative petition should be maintained because it was a very serious criminal case. And I never heard about that case after that. I was not even told whether curative petition was filed or not. So legal aid system, which is supposed to cater to these poor and the needy who can't get good legal advice, is in a complete shambles, I would say. So far as the second question is concerned, let me say one thing, that to defend Prashant was a great privilege for me. And I had definitely, it was I must say one thing, that with all their views on the matter and perhaps some reservations about me, Justice Mishra allowed me complete freedom to argue. And I did put every conceivable point to the judges as to why judiciary had lot to really be, a lot to introspect, and why judiciary should really not be running after somebody like Prashant Bhushan. And, and judges heard that, all that very willingly. And they, of course, the judgment when it came, none of those arguments have been incorporated at all. But fortunately, in today's time, social media is so, omnipresent, that every one of those arguments was, given out, and people heard that. And it's a matter of great satisfaction that people at least saw that we could make a genuine, strong effort to tell the court that freedom of speech is something which must be guarded very, very jealously. And Supreme Court has done that right from 1950, and that to muzzle that freedom in the threat of contempt was really not good for the nation, not good for the Supreme Court.
Justice Shah, I'm taking the liberty of combining two questions combined and one second question, which is on an unrelated subject. So basically 2A, 2B, and one more question. One is about Shailesh Gandhi ji has asked about, is our judicial machine not the consequence of opaque and arbitrary selection of judges? And what is your view on how judges' appointment should take place? Related to this is a question from Dr. Goldie George, who said that if the government, on the other hand, is allowed to appoint judges today, the Modi government will appoint all RSS cadres as judges. So what is the solution? How can the secular democratic fabric be actually preserved by the judiciary? And an unrelated question on a completely different subject comes on the very, very tricky question of female genital mutilation, which is a practice, abhorrent practice within the Bora community. And what should be the way forward when in terms of, because the courts have taken a one step forward, two step backwards role, though some feminists and activists within the Bora community have raised it. So how do we visualize it in the perspective of human rights violations? This is from Zainab. Justice Shah.
Now, as far as the appointments are concerned, I must emphatically say that we cannot go back to the old system of executive appointing the judges in consultation with the Chief Justice of India. We cannot revert back to that system. This is out of question. The present collegium system is completely undemocratic. It is completely opaque, and it has many shortcomings. It functions like a cabal, a club. I mean, that what Dushyant said, that the actually, it's some sort of a bartering between the members of the College of Wits. So perhaps the NGAC would have been an ideal solution. At that time when the petition was heard, the court had an opportunity to read down the law and to make it to, for example, to have majority of the judges in the NJAC, or to somehow or the other, change the procedure so that the executive would get a minimum possible role in the appointment of the judges. But I'm also against this idea of judges appointing the judges in a very non-transparent manner. See, picking judges is unknown to in most of the judiciaries in the world, the democratic judiciaries in the world. So we must have a different kind of a system. But in the present situation, I personally feel that I do not see any alternate. And I remember one more thing. At one time, this government was very keen to bring the NJAC. They wanted this power. But now I think they don't speak about the NJAC at all. The reason is that they have successfully, according to me, penetrated the appointment system. So today, the government has some, as I said, that some appointments, some transfers are actually orchestrated by the executive. So in a way, the government has a say in the present system. So maybe I frankly, it's very difficult to answer this question, except saying that we should have a National Judicial Commission, which is acceptable to all political parties and also to the judicial, to the legal fraternity and the citizens of this country. And about your second question, frankly, I'm not aware of these practices, but surely this would be. I want to know whether this is also one of the cases referred to the 7-judge bench. This practice in the Bohra community.
Yes.
I personally feel that the time has come to clearly define what is an essential practice. This Bohra committee's earlier case, which went up to the Supreme Court, where the question was of the right to burial. That was the community's right was upheld. But the really, I would approach it from the constitutional point of view, that whether this practice is consistent with the constitutional ethos or what the judges have often said about constitutional morality when they dealt with the Sabrimala case, as well as they also dealt with the Haji Ali and the other cases.
Thank you, Justice Shah. There are two more questions, Justice Shah, particularly addressed to you on the brazen attempts to criminalize dissent by the regime in power today. Of course, you already referred to them extensively in your speech, but I will still repeat, because the person asking the question is saying, what do we do when you have this criminalization of dissent, both in the Bhima Koregaon case, when 12 of our human rights defenders are there without bail and without any hearing, either in the lower court, high court, or even the Supreme Court. And then in the Delhi cases, you see that the real perpetrators of insightful speech, incendiary speech are not even prosecuted, and you find young student leaders, activists being incarcerated. Related to the Delhi violence case is one more question, that the recent case of some younger persons getting bail, do you see this as a positive trend? And why is that happening?
See, personally, I feel that that people should raise their voices against this very blatantly unfair and motivated investigations in Delhi riots, and even what happened in UP and the other places. Where
and Bhima Koregaon, sorry.
Also. Sorry. But this is at one level, that where actually when Mr. Ribeiro wrote to the police commissioner of Delhi, some other former police officials also wrote to him, and the result was that the police, I would say, really, sort of took one step back, because they clarified that they are not going after Professor Apurvanand or Yogendra Yadav or two other professors, and the one filmmaker. But really, I mean, this explanation is completely false, because if they were not implicating these individuals in the riot cases, then why there was a need to mention their names?
Yeah,
so
exactly.
really, the raising a voice will have some effect. Secondly, I don't know. I'm not now. No, I don't no longer practice. But secondly, I would request Mr. Dushyant Dave to take up this Watali case, which is really creating a problem, where the court has practically let down such absurd doctrine that the material produced by the prosecution cannot be tested, by the police cannot be tested at the bail stage. So that there is some sort of a review should be sought of this judgment. Unless that judgment is overruled, I'm sure I'm very pessimistic about the fate of these people who are languishing in jail for a very long time. And the problem with the UAPA is that the police keep on getting extension of time for filing charge sheets. I don't know when the trial will happen. I can tell you this much: I have studied Sudha Bharadwaj's case, and I feel that the trial will be over in half an hour. There is nothing to be tried. This is the whole prosecution case is based on the inadmissible evidence. But I'm not sure when the trial is going to take place. So this is one case, one issue which Mr. Dave and his colleagues should take up in the Supreme Court.
Thank you, Justice Shah. We will wrap up with final two more questions for Justice Shah again. One is a philosophical question, and one is a question in anguish by a young lawyer. The question in anguish is that my question is, what do we as an advocate do, Justice Shah, when my poor client is released after 15 days or maybe more getting bail, but a BJP MLA is released on the very same day? And the second question, Justice Shah, is that Dr. Ambedkar raised a question time and time again, whether democracy is a rule or a principle, whether law is to be understood as a rule or a principle based on justice, equality, liberty, and fraternity.
No, of course, there is no doubt that it has to be based on principle. Unfortunately, see the bail applications. For example, you remember the old jurisprudence which was really laid down by Justice Kushnaiyer and the other judges. So this jurisprudence regarding bail was consistent with Article 21, right to liberty, and the bail was a rule, and the detention was, or imprisonment was an exception, incarceration was an exception. But now it is turned on its head. I mean, this is complete perversion of the bail jurisdiction. And what is happening in this country is very strange. See, generally, the police first collect evidence, and once it collects sufficient evidence, a person is arrested. But here it is exactly in the reverse way. The police arrest the person, and even though the crime might have been had been committed much long long before, but this is the way in the investigation is conducted in this country. So I do hope that some judges would really reconsider the current situation and try to restore the bail jurisprudence which was so eloquently elaborated by the judges like Kushnaiyer. Is the need of the time. And really in individual cases it's very difficult to give opinion as to why. One of the why these systems are discriminatory, because I mean this we realize in particular in death penalty cases. You will never find a rich and a powerful person given death penalty. I never seen a punishment which is so discriminatory than death penalty.
Yeah.
See, the 99% of the cases are just poor and marginalized people are sent to gallows. So that's unfortunately the part of our system.
Justice Shah, I think I'll take the liberty of giving one more question because of particularly the references you made in your outstanding lecture. And it comes from another young law student, that does the Supreme Court really have the power to define what is an essential practice of a religion? Doesn't it defy the autonomy and freedom given to the religion and institutions? And I think there'd be nobody better than you who could answer this question.
No, it's very difficult to answer. This is a very complex issue. It's very difficult to answer give some answer offhand. But I can tell you this much, that for example, I can give just one example, something bordering on the untouchability, that certain people will not be allowed in the temple because they are untouchables, they are Dalits. Now, can it be an essential practice of the religion? These questions were asked. Now, will you not apply this principle? Because, I mean, as Justice Chandrachud put it correctly, according to me, and this was the same view taken by Justice B.P. Sinha, that when the practice they said that this practice amount to virtually a bonded labor, untouchability. So you are excluding certain people only because of their birth in a particular community or particular religion. So maybe I'm not in favor of saying that that essential practice test should be completely dispensed with and the religion should be given all the freedom. I look at the secularism from a very different point of view. According to me, the secularism does not mean that you are not in the Western definition, but secularism means that you must respect all the religions and not those who practice the religions should also respect the constitution of this country. I mean, when they practice their religion, it should not be in such a way that it becomes completely unconstitutional. But these are very complex and issues where I cannot answer it. Perhaps
I want to say something
really
to that.
participate
Please.
in that seven-judge bench.
Let me respond to that question.
Of course, please.
In my view, any religious practice, however old it may be, if it violates the fundamental rights of citizens, that practice has to stop. As Justice H.R. Khanna very beautifully puts in his powerful dissent in ADM Jabalpur, fundamental rights are not fundamental because they are provided in the Constitution. Fundamental rights are only embodiments of basic human rights and human values. Now, if these practices are against basic human values, basic human rights, then I think those practices must change. Everybody must learn to change. After all, religion as was conceived 3,000 years ago or 2,000 years ago, must undergo a serious rethinking amongst all the people in a democratic setup where we want to value and respect everybody's dignity and everybody's right. So I think to that extent, that practice must be held to be unconstitutional. I have no doubt.
Thank you so much, Justice Shah and Dushyant ji. Just before I hand over to Irfan and my colleague Henry for the vote of thanks, I'd just like to say that, on the issue of discriminatory justice and death penalty, apart from the fact that it's the rich and the powerful, it's also the ones who are privileged in terms of caste, community, race, who are generally the ones who escape the long arm of the law. So we've seen excellent studies down on that, but I think, like everybody said, society and people need to be educated by the structured inequality that we continue to have 72, 74 years after independence. We've had a very, very august gathering today from Justice Madan Lokur, Justice Radhakrishnan, Professor Hargopal, Justice Sikri. I mean, I don't want to say how many people have joined us apart from Mr. Ansari and Mr. Wajahat Habibullah. Thank you so much for this opportunity, for this being part of this absolutely humbling and inspiring evening. We need to take this forward, as Dushyant ji said so passionately, that it's not enough for individuals to do what their conscience believes, but we need to take far more rigorous steps to try and ensure that a movement develops from all these values and sentiments. Over to you, Irfan.
Thank you, Tista. I will not take much time. It was an excellent evening. Both expositions were very great. Participants were very great. And all the organizations that has organized this, we would continue the work of educating people about their rights, resisting authority and authoritarian government, as Advocate Dushyant Dave has pointed out, and as Justice Shah has pointed out. We'll carry on this struggle. This doesn't end with this, but we all together will carry on. With this, I request Henry to propose a vote of thanks. Andy, unmute yourself.
Thank you, Irfan. Thank you, friends. Let me start. I'm not going to repeat a word of what has already been said. Thank Justice Shah and Mr. Dave for that wonderful presentation that both of you made. I think it is a hopeful presentation. We derive hope. There are lots of people on the chat who have mentioned this. We go back this evening with a very, very honest presentation made, but go back with a lot of hope. And the silence of these institutions is versus the silence of the people is where Dushyant left us after his lecture. So thank you both for this, and I'm sure we will continue listening to this on the recorded message, but also look forward to this being transcribed into a book. I want to thank the three chairs, Irfan, Mihir, and Tista, in different parts of this evening's function for their wonderful presentations that they made at each level and ensured that the flow was maintained. Thank you, Irfan. Thank you, Mihir. Thank you, Tista. Thank you very much, Suhail Banerjee, for that film, for that short but very, very, very well presented film. And we will remember the last words that came from the daughters of Justice Suresh. Also to Kishan Bhagat for the film award part of the program, where we were able to see the three daughters together receiving the award. Friends, we would like to thank wholeheartedly the Bora Youth Association Tansan, the Central Board, Dawoodi Bora Community, the Center for Study in Society and Secularism, Citizens for Justice and Peace, the Institute for Islamic Studies, Majlis Law Center for co-organizing this entire event along with People's Watch. I think this is a wonderful event we have put together. I mustn't forget to also thank Commander Mansoor Ali Bora for his part of the presentation that he was able to make, Flavia Agnes for being with us from the beginning as part of the organizing team, and all the others, particularly who participated today, all the judges who are present here, the lawyers who are present here, the journalists who are present here, those who are tweeting throughout the program. This is an event which is paying very great respect to two people. But at the same time, this event is also leaving us with a lot of hope that we will be able to continue the struggle with the type of people that still exist here. Thank you very, very much.
Today evening, a lot of young lawyers have been inspired, and we see a lot of in the chat box their gratitude and inspiration to carry on this and be their strength. Thank you so much once again.